Hello everyone, this is the Law Raven. The legal year opening is upon us, and I would like to take this time to explain exactly the significance of the legal year opening. For the average person, the legal year opening actually means courts can begin sitting for purposes of hearing matters. Cases can now resume. It is a significant moment in the legal profession because it means the gloves are coming off now. It's time to hit the ground running. It's time to litigate debt collection, to institute legal proceedings, to make tough decisions. And that's for everybody who's affected, because the legal profession only works if people have social disputes, have problems that need to be resolved. And it always boils down to the individual who has to decide whether to proceed to litigation or they would rather settle their disputes out of court. Which leads me to the most significant point of this video today. Why litigation is expensive. I know most people would say lawyers are expensive, which is not true. It's the fact that litigation itself is expensive. It's the service that's expensive, not the individual. Okay, so let me explain it this way. Litigation is expensive because evidence is expensive. Full stop, that's it. Litigation is expensive because evidence is expensive. Most people don't have documented evidence. So when you go to an attorney because you want to take legal action against someone, in most cases, the plaintiff or the client doesn't have the necessary documentary evidence to back up that claim. Additionally, you may also have witnesses whom you need to testify on your behalf. Those witnesses need to be transported to and from court. They need to be fed. They need to be accommodated. That's costly. If you are litigating in Francistown and you have your witnesses are based in Gaborone or some other parts of the country, you have to pay for that transportation so they can come and help you win your case. That's the first factor, the first reason why it's expensive. Another reason why litigation is expensive is the fact that you have to authenticate text messages. When it comes to litigation, strictly speaking, you cannot use screenshots as part of evidence. You cannot use text messages from your phone. You can't show them to the court or to the other party. That's not allowed. You need to get a record of those particular text messages from the service provider. And for the service provider to give you those records, they would require that you bring a court order that speaks to those that confirms the text messages. And for the service provider for you to get the court order, your attorney has to make a special application to the court for an order directing your service provider to issue the text messages ranging over the period that you claim those text messages were exchanged. Another reason why litigation is expensive is the time factor. It cannot be avoided. Most attorneys have to spend time on drafting your papers. They have to spend time addressing the court on your behalf. That's costly, that's time, that's hourly rates. It's a billable service. You cannot avoid it. So, if you're contemplating taking legal action or instituting proceedings, understand that litigation is expensive. If you are halfway through your case or if you are still continuing with litigation, sometimes it can cause burnout, both for you and your attorney, because litigation can stretch for years. It can go from 1 year to 5 years and you're still litigating over the same issues. And half the time you wind up presenting the attorney who provides the service not because they are to blame, but because the whole system is there's so much backlog and it takes time to conclude matters. This is why litigation is expensive. The procedure that must be followed during the litigation process, especially in civil cases. First of all, you'd issue a summons or an application in the form of a notice of motion. You'd serve the respondent. The respondent must be given a chance to respond. Thereafter, you may reply. The same thing applies when you issue a writ of summons. The defendant must be served. The defendant is allowed time to respond. And as a plaintiff, you are allowed time to reply to their response. Before those stages can be accomplished in full, there is room for technical points to be raised by the respondent or the defendant. They might allege that your papers do not disclose a course of action, a case to respond to, or that there's some irregularity in your papers, or that your papers have been badly drafted. That would force you as a plaintiff to withdraw your application or your summons and correct it, or it would force you to file an amendment and then serve the other party. And when you withdraw your application or your summons, you are supposed to pay costs to the respondent or the defendant. Why? Because you've wasted that time. This is why you are expected to pay costs. So if your papers are badly done from the onset, if the respondent highlights that fact, you have no choice but to withdraw or ask them if they can allow you time to correct the papers without demanding costs for wasted time. Pause. After exchanging the summons and the responding papers with the defendant or the respondent, you are expected by law to have what you call case management. This is where both parties must meet to try and come to a settlement, to explore whether there is room for a settlement. If not, they then have to come up with the issues that they want the court to deal with during trial, the issues that they want the court to answer at the end of the trial. This forces the parties to actually have a meeting, a civil meeting, where they can draw up a report advising the court as to whether they've decided to settle out of court or they still want to proceed to litigation. That report gives so many options for applications that can be made and exchanged between parties. It is during that case management conference that you'd find there are more costs incurred when you have to make an application for example, an application for discovery, that is to say, for the production of documents that you don't have but you need. If you have a document at the land board or a copy of your certificate at the land board and you no longer have it yourself, you need to make an application to the court to compel the land board to issue a copy of that document. So it can be a cumbersome process because it means you have to pay, or your attorney has to make an application, which is something that they also have to charge you for. It's a billable service. Even before you get to the trial stage or to the argument stage, by the time you get to the trial stage, there's a lot of paperwork and processes that have to have been done by both you and your attorney. And by that time, there's so much that you would have spent on the litigation process. Then during trial, you make sure you secure your witnesses, you get everybody who needs to come and attend court in order to testify on your behalf. Okay. After the trial has been concluded, the court will set a date for judgment. On that date, you will find out whether your application or your claim was successful or it was not successful. If you are successful, you succeed with costs. Costs are awarded because you had to litigate to enforce your rights, when you could have avoided it if the respondent or the defendant had paid you without making you work for it. If your case is dismissed with costs, you have to pay the defendant for putting them through the trouble of defending a case that turned out to have no merit. This is why costs are ordered. This is why people have to avoid litigation by all means. If somebody claims money, if somebody demands what's due to them, come to an understanding, make a payment plan, make an arrangement out of court in order to pay them, and stick to that payment plan. Try by all means to liquidate your debt. Try by all means to meet them halfway, or to fulfill your obligation to them. So assuming you were successful in your application or your lawsuit, you were granted a judgment in your favor. If it's a judgment that results in payment, or judgment that grants you an order for payment, you then have to demand that the defendant pays you within a specific time. If they fail to pay, enter the deputy sheriff. You now have to apply for a writ of attachment of property, because the defendant refuses to voluntarily pay you the money that's due to you. So the next step is to apply to the court for a writ. A writ is a document that allows you to attach movable assets. You apply for a writ of attachment of movables. Once you get the writ, you engage a deputy sheriff who is authorized by law to enter into somebody's premises, to attach goods, to attach property, to make an inventory, and even sell it, advertise it and sell it, so that you can recover your debt. If the deputy sheriff cannot find anything valuable or anything that can be attached or salvaged in order to help you recover your debt, they will issue a report. That report will indicate that there's nothing to attach. It doesn't necessarily mean that the house is empty. It just means the couches are too dilapidated, and it would be a waste of time to even try and attach that. So it's an assessment. So when he says there's nothing to attach, it means there's nothing valuable that he can attach in the hopes of helping you recover your money. Once you have that report, you have two options afterwards. If your defendant is gainfully employed in a stable job that pays consistently in a parastatal or a government entity especially, you can apply for a garnishee order. That is to say, for a stop order, deduction from their salary on a monthly basis. You can apply for a stop order, which allows you to get paid the same way that a bank would get paid through somebody's salary. Constant payment, a constant deduction of payment from their salary. Alternatively, you can apply for civil imprisonment. That is to say, the defendant has refused to pay and they have no assets that I can attach. And then you apply that a warrant of arrest be issued for that civil debtor. Once the warrant has been issued, engage the deputy sheriff again. This is where they come in, so that they might arrest and detain the defendant for a specific period of time, during which time you want to believe they will come to their senses. They will start to prioritize your payment as they do with all other payments. It could be 30 days, it could be 60, some go as far as 90 days. That is something that you choose civil imprisonment with the hopes that the defendant is responsible enough to understand the implications of having a civil imprisonment order issued against them. Some of them work, they have to get to work every day. So if they are arrested today, it means they are not going to be turning up for work and they are likely to be dismissed from work. So it's a priority issue. It's an issue where you are compelling the defendant to prioritize your debt because you're holding a court order that could deprive them of their freedom of movement, freedom of movement for a significant period of time. But the purpose of this video was to try and highlight why it's expensive to litigate. Money is paid from stage 1 throughout the trial. It doesn't end with judgment. There's the enforcement stage where you must make sure your judgment is obeyed. When you engage a deputy sheriff, he must be paid. Every step that follows after judgment requires that you part with money to engage people who can assist you with doing your work. You cannot attach goods personally. They must be attached by someone empowered by the court to do so. So we circle back to why litigation is expensive. It's both for the evidence and it's also expensive because enforcement of judgments is expensive. You cannot do it alone. You need to engage specialists, individuals who have the authority to go to places that you cannot go on your behalf. Can't be avoided. So if you are ever invited for case management conferences to meet and discuss a settlement, you lose nothing by attending the meetings. Have a sit down, hear what they have to say, find out if the offer is worth it, and weigh the cost of litigating against the cost of settling your dispute. Let's chat again next time. Thank you for tuning in.